So, getting started then with today's session, the title is International Law at the Vanishing Point of War. And with today's session, we're asking what are the stakes for humanitarian organizations in the ongoing application or not of international humanitarian law, for example, in Afghanistan, but also in other contemporary armed conflicts. We're asking, does international law provide sufficient guidance for humanitarians and other battlefield actors to discern when today's armed conflicts end? And we're very pleased to have with us again and to welcome back Modirzadeh, who is the founding director of the Harvard Law School program on international law and armed conflict, that's PILAC for short, and her colleague Dustin Lewis, senior researcher at PILAC. And we'll be starting off today with a presentation from Naz, an initial presentation really focusing in on what are the key stakes involved in discerning whether IHL continues to apply. Then following Naz's remarks, we'll move on to Dustin for a more detailed presentation on what IHL has to say about the end of non-international armed conflict in particular, but also doing some comparisons. So without further ado, I'm going to pass the floor over to you, Naz.
Great, thank you so much, and Herod, and thank you to the PHAP team for having us. It's wonderful to be back. I really think these events are such a wonderful way not just to discuss new research or new dilemmas, but also to connect with so many friends and colleagues around the world who are not just thinking about these problems, but living many of them, as you can see already in the chat. So today we are talking about a topic that I'll say at the outset can seem a little bit boring. We are talking about a topic that it can become a highly legalistic discussion and one that I think can quickly appear academic and abstract. And so the challenge that sort of PHAP gave us and that we've been thinking about over the last week as we explore an ongoing research project of ours on the end of armed conflict under IHL is how do we talk about this question about the end of armed conflict under international law in a way that is connected to reality and in a way that is connected to the lived experience and real challenges for humanitarian actors. So I realize that is a bit of a strange preface to a presentation, but I want to be very honest and open that this is a topic that I think we are still thinking through what the implications and stakes are for humanitarian actors, and we would really invite PHAP members to engage us on that question, both in this discussion and moving forward if they feel so inspired. So very briefly, our goals for today are to identify and evaluate some of the key aspects of international humanitarian law concerning the end of armed conflict. So the reason we have quotes there is what we are trying to think about is what does international humanitarian law say about its own stopping point, right? At what point do we know that IHL no longer applies? And then second, to highlight sort of what are the key approaches to this question right now and what might be some of the implications of those approaches. I'll say at the outset that PILAC is not an advocacy organization, and on this topic in particular, our approach really is trying to sort of map out what is out there in terms of legal arguments and views. We're not putting forward our own normative or prescriptive viewpoint on this question. So I'll begin with an overview of sort of why I'd like to suggest that this topic matters to humanitarian actors and to PHAP members, with a bit of a question mark, as I said, so with a bit of an opening for discussion and feedback on that. And second, my colleague Dustin will really dig into some of the law and explore what do we know right now in early 2016 about where IHL appears to be on this question of the end of armed conflict and the end of the application of international humanitarian law, two things which, of course, might be different from one another. As I noted, Dustin will go into some detail, so I ask that everyone hang in there, and then we'll bring it back out, I think, and talk through what some of the implications might be for practice, access, humanitarian activities. So let me just very briefly talk through some of the stakes as we see them with an eye to humanitarian practice and humanitarian action in contemporary armed conflicts. And I'll just begin with a statement that I think for us at PILAC really got us focused in on this question. President Barack Obama, right after Christmas 2014, gave a speech in which it was a much anticipated address in which many said he would essentially make clear the end of the U.S. involvement in the conflict in Afghanistan. And he said, thanks to the extraordinary sacrifices of our men and women in uniform, our combat mission in Afghanistan is ending, and the longest war in American history is coming to a responsible conclusion. I read that out loud just to say, for many of us, I think that seems pretty clear. The President of the United States is saying that the American war is ending in Afghanistan. Many news outlets sort of announced that and sort of said the President has said that the war is over. And I think many anticipated that the next challenge would be kind of how to administratively implement the end of that conflict. Soon thereafter, several months later, General Campbell, the highest-ranking U.S. military official on the ground in Afghanistan, gives an interview in which he seems to suggest, well, maybe it's not that clear. Right? So General Campbell suggests, for me, it's not black and white. And the line between war and the end of that war is perhaps a bit blurrier than the politicians back in Washington have to say it is. There was also a significant amount of analysis, and here I would say Professor Rosa Brooks is probably a leading thinker in this area, but not alone at all in this analysis, that we are living through a time when the line between war and peace, war and not war, is going to become increasingly irrelevant. That the next era of international law and international relations will be one in which the Geneva Conventions will appear not simply ill-suited for, but almost inappropriate for a time when there will always be some kind of low-grade conflict, and there will be a much more complex relationship between war and peace, human rights, and IHL. Finally, we have a increasing, if not recognition, then rhetorical nod to the notion of counterterrorism operations as distinct from combat or armed conflict. And this is, of course, not a legal statement that we have quoted here on the PowerPoint, but we're seeing this a lot in references in the media and also statements from government officials, and not only U.S. officials, I might add, the reference to counterterrorism operations as somehow distinct to armed conflict. So what you have here is a switch, and I put the switch here just to emphasize that we tend to think about international humanitarian law as having an on switch. And so when we talk about all the rules of IHL, both those related to protection and humanitarian protection, but also, of course, those related to the conduct of hostilities. As many have said, international law is unique in the fact that it regulates both unlawful and lawful violence, right? It's a regime of the regulation of lethal violence. And we talk a lot about what the on switch is, right? We talk a lot about when does this legal regime begin to apply. We tend to talk a lot less about when this regime stops applying. So where's the off switch? And I'll just close by suggesting Our preliminary research and our, sort of, I would say, our first 6 months of thinking about this question and engaging various actors on this suggests that there are, I think, at least sort of 9 stakes or 9 types of issues that are affected by the question of the off switch and should matter to humanitarian actors as they receive the kinds of statements that we had on the slides earlier, as they hear governments, multinational operations, and others appearing to reference an end to hostilities or an end to conflict. Here are 9 things that we think might be worth considering in terms of the implications for humanitarian actors. And they are not at all in order of importance, so I'll make sure that that's clear. So, of course, the first and most obvious is targeting authority, right? In what ways does the determination of the end of armed conflict mean that there is a clear end to the authorization for or the regulation of legal, lethal targeting by parties to armed conflict? The second is the destruction of property and infrastructure. So, of course, for many humanitarian actors on the ground, it is not only their own infrastructure and property, but also the legal ability for parties to armed conflict to destroy property in their pursuit of victory that we assume comes to an end at the end of an armed conflict, or we need to know when it will come to an end at the end of an armed conflict. Third, the question of detention and the deprivation of liberty. So as all PHAP members know, there is, of course, a very special regime of detention and deprivation of liberty under international humanitarian law, one that both provides authorities for the parties to armed conflict to detain, but also provides crucial protections for those who are deprived of their liberty. When does that stop? When can those people expect that they will be released because the conflict has ended? There are, of course, famously a number of detainees in the Guantanamo Bay, Cuba detention facility who are wondering very much what will happen to their fate now that President Obama has made this statement. Fourth, the question of humanitarian access and assistance, including, crucially, fifth, the provision of medical assistance, not only to civilians, but also to wounded fighters. Again, a very particular regime, and our initial research suggests a number of humanitarian actors do indeed root many of their claims for access in IHL. So at what point do humanitarian actors need to know we can no longer reference those particular claims of IHL? Thinking through sort of the human rights regime as opposed to the IHL regime, and whether or not there is sort of a concerning revolving door or moving in and out of conflict in a way that affects who owns the legal space, right? To whom do you turn to if you are a civilian in a particular context where it is not clear whether or not an armed conflict has ended? And finally, thinking through legislative authority and governance, right? So at what point is there an expectation that you are returning to some kind of peacetime governance, lawmaking, and legislative authority? So I'll just close with a few issues that we might want to think about as we turn to Dustin's analysis of international humanitarian law. And I do want to mention here that we were profoundly assisted in this research by our research assistant, Sasha Pippinger, who's done much of the background work on the law that Dustin will be looking at. So a few suggestions for sort of how to maybe approach the legal doctrine. The first is the question that we rarely talk about, that if there are a number of states involved in an internal armed conflict somewhere else, right? So if the United States is involved in the non-international armed conflict in Afghanistan, does IHL apply back in the United States? And if so, what happens when the United States is no longer, or says that it is no longer engaged in that armed conflict. So what happens legally, what happens to people who are detained, but also what happens to sort of the wartime authority in any territory where IHL might apply. Second is the question to ask ourselves, sort of, is IHL, do we understand IHL primarily as a permissive or authorizing regime, meaning it, to put it crudely, is a license to kill lawfully, or is it a restrictive regime, one focused on protection? And finally, to ask ourselves, and I think this is for us one of the most important elements of thinking about this problem that can sometimes seem very abstract, what does this issue look like from the perspective of a civilian on the territory of the place where this is happening? So, for example, if you are living in Afghanistan and you are an Afghan, how does this affect your life? And does it affect your life in important ways? And should the determination of war or not war create clear differences in sort of what life is like? And then what does it mean if you are a humanitarian actor operating in this area, both in terms of law and in terms of the very practical realities of operational and strategic decision making? With that, I'm going to turn it over to my colleague Dustin to take us on a quick journey through international humanitarian law, and then we're going to speak to some special guests and open up for questions and comments. Dustin?
Great. Thanks very much, Naz, and thanks everybody for participating today. As Naz mentioned, I'm going to try very quickly to outline the key elements of IHL concerning the end of armed conflicts. We'll go through a very, very brief summary, starting with the four main axes that we talk about when we talk about the legal scope of application of IHL, and then look quickly into international armed conflicts, or IAC as we call it, and then more time will be spent on non-international armed conflicts, since that's the majority of armed conflicts today are non-international armed conflicts, also known as NIACs, and because there's much less clarity around exactly what the legal parameters say the end of armed conflict looks like. And we'll put forward or try to identify three different theories that we've brought out of the research with our colleague Sasa Pippinger on how we might think about the end of armed conflict under international humanitarian law with respect to NIAC. So first things first, as with almost all international law and armed conflict questions, you can break down the analysis of whether or not IHL applies on four axes. And these are the ones that I always recommend lawyers turning to first, as well as humanitarians or others who want to be able to discern the scope of application of the law. The first one being the geographic, so where is it taking place? The second one being the personal, who is affected by this, who is governed by it, not only the parties but also the people to whom the protective norms would apply. The third being the material scope, so what exactly is what's the subject of the legal protection itself? And then the most important one for today, the temporal aspect, so the timing aspect of it. Again, these are just broad brush overstroke here. The key four elements trying to discern the scope of application of any IHL thing. If you can discern these, then you're in really good shape. But as I think we'll see, it's very complicated to do so today for non-international armed conflicts, not only along the temporal portion or axis, but also along the other ones as well, as we'll get into a little bit. So I think to best understand how we can see the end of armed conflict in non-international armed conflicts, we have to go back a little bit to see how the conceptual changes have occurred within the framework of international armed conflicts. So we'll start right now with international armed conflicts, also known as IACs. So up until 1949, the notion of armed conflict didn't carry any salience within international law. It was war or it was peace. There were other regimes around neutrality and whatnot, but there was no concept of armed conflict. It's in 1949 with the Geneva Conventions that this notion of armed conflict becomes extremely important. And it's no longer is the application of IHL predicated on the declaration of war or the finding of a peace, but rather on a factual predicate, something that's supposed to be objective. Can you actually say that there is certain conditions that are met such that an armed conflict exists. One state has engaged in hostilities against another state, irrespective of whether one or the other of those states actually says that there is a declared war. And alongside of this, you have, falling into desuetude, the notion of a declared war. The U.S. hasn't declared war since 1942 or 1943, I think. The last one was against Romania. But they have been involved in many armed conflicts in that time. So the key point here is that there's a conceptual change that occurs in 1949, and it's this move from war or peace to the existence or non-existence of armed conflict. In international armed conflicts, there's many more treaty provisions that concern the exact temporal scope of application. So again, international armed conflicts, or IACs here, armed conflict between two or more states engaged in hostilities, or situations of belligerent occupation, even if it's meeting no armed resistance. But the upshot is that there's two main treaty provisions on this, two main notions. The first one is the general close of military operations, and the second is the cessation of active hostilities. In the treaty law, the cessation of active hostilities pertains in particular to prisoners of war. If you look back in the lineage of this, you see then the 1929 Prisoners of War Convention that it was a bit unclear exactly when you had to repatriate the prisoners of war, whether it was once the battlefield lines, once it was clear enough in the offering and whatnot, and they tried to make it a bit more clear in 1949 by saying as soon as there's a cessation of active hostilities, then you need to repatriate. And then there was this notion of a general close of military operations. Whether or not these are synonymous, though, is up for dispute in some ways. When you look into the travaux, or the preparatory text accompanying the 1949 Geneva Conventions, it's not entirely straightforward. Some of the delegates were mindful of this distinction between the end of a state of war and the restoration of peace as they contemplated these concerns. But the records of the deliberations seem to suggest that the delegates understood that as a factual reality characterized by the absence of hostilities, that would be the state of war, and that the legal reality accomplished by the conclusion of a peace treaty would be when you get into peace. Exactly when the military operations ended was left a little bit ambiguous. And again, this is this really important move from pinning the IHL framework, the international humanitarian law, the LOAC framework, to the state of war or peace, to this existence or non-existence of armed conflict. The last thing I'll note here is that in drafting the Geneva Conventions, the delegates seem to not have that much concern exactly for the scope of close of military operations versus cessation of active hostilities. The nomenclature here seems instead to have resulted from the fact that in some domestic systems, such as France's, the legal system required that the government establish the conclusion of hostilities by legal decree in order to repeal internal war legislation, and that the general close of military operations and that the conclusion of hostilities were meant to be synonymous in some way in this context. And then we go to 1977, the next key legislative moment, if you will, of international armed conflict with Additional Protocol 1. Additional Protocol 1 uses the same terminology around the close of military operations. This applies, by the way, with respect to all of the people, with respect to all the provisions of the Geneva Conventions and Additional Protocol, except those that apply to people who continue to be held in the adverse party's hands. So even if the armed conflict ends, if you're still being detained, you still benefit from all of the protections of those conventions. A curious thing seems to have appeared, though, in the commentary on Additional Protocol 1. There, the ICRC, the International Committee of the Red Cross, appears to have said that, in fact, the general close of military operations may occur after the cessation of active hostilities. And with that, we see this potential move, this potential distinction all of a sudden between what the 1949 conventions mean by cessation of active hostilities or close of military operations, and what the Additional Protocol 1 version means in terms of whether or not there's a distinction between cessation of active hostilities and general close of military operations. Both, of course, though, have this endpoint of peace treaty as being the very clear marker of the state of peace, But the general close of military operations for both would be the ultimate end of an application of IHL with respect to those particular conflicts. So why focus on the IAC provisions when we're focusing on the non-international armed conflict ones today? Well, mostly because there's much more law and much more commentary on the international armed conflict provisions, and the NIAC ones, the non-international armed conflict ones, seem to be rooted in it. So for the next about 10 minutes or so, I'm going to try to give a sketch of what the key considerations are with respect to non-international armed conflict in particular. As a prefatory point, when we talk about non-international armed conflict, sometimes people say an internal non-international armed conflict or an extraterritorial NIAC. Some people even today talk about a purported transnational NIAC. We won't get into many of those distinctions here because the legal distinctions, at least in the treaty provisions and what most people would consider to be the customary law provisions, of course, treaties and customary law being two of the primary sources of international law, international humanitarian law in particular, that they don't seem to make a big distinction between these. But you might hear somebody also talk about a civil war or an internal NIAC. Here we'll focus just on non-international armed conflicts in general. Obviously, they're increasingly complicated today given the fact that oftentimes, even though multiple states are involved in a single armed conflict, it's still characterized as a non-international armed conflict, for example, in Afghanistan today by most commentators, even if, because those states are doing so at the invitation of that host state. So you can have 50 states involved in a non-international armed conflict. So what's our key question that we're addressing today? Is there a legal rule that we can identify that guides the determination of when a non-international armed conflict, in particular in a way that IHL would cease to apply to that non-international armed conflict? As my colleague Naz had mentioned, there's many stakes involved in this for humanitarian actors, for civilians, and for others. But for now, I'll just focus on the legal issues and then try to give you a sense of how unclear at least many of the legal issues are. With international armed conflict, there are two key sets of legal provisions in general, treaty provisions. The first is Common Article 3, and the second is Additional Protocol 2. So I'll look first at Common Article 3 here, and then I'll turn to Additional Protocol 2. Common Article 3 accompanied the 1949 Geneva Conventions. It's called Common Article 3, of course, because it's common to all four of the 1949 conventions. But it is silent as to the temporal aspect of the end of IHL's application. When you look into the travaux, it appears that the drafters expressly declined to define even more broadly what constitutes a non-international armed conflict. You have developed instead in the commentary written by Jean Pictet what ends up being called the Pictet criteria, which are 10 or so factors that a lot of people up until the 1977 and even up until the ICTY jurisprudence would consider to be one of the more authoritative sets of factors to consider when it comes to non-international armed conflict. But these don't give us guidance on the temporal aspect. So in short, Common Article 3 does not give us sufficient guidance on when non-international armed conflicts end. And as with many of those other axes of application, geographic, material, personal, temporal, it leaves a lot of room for maneuver as the way that states drafted it. So, moving to Additional Protocol 2. In 1977, alongside the drafting of Additional Protocol 1, the states adopted, or a number of states adopted Additional Protocol 2. Additional Protocol 2 is considered to have a higher threshold of application because it has certain criteria that the parties must meet, and it has a specific provision on its geographic scope as well. So here we've tried to delineate the four key elements of the scope of application of Additional Protocol 2. You'll see that it has provisions on every aspect of it in terms of these four. The geographic is that it would apply in the territory of the relevant high contracting party. The personal scope of application is that it'd be all persons affected by the armed conflict. And the material is that it would exclude internal disturbances and tensions, etc., and that it would only apply with respect to certain conflicts that meet the criteria for a high contracting party versus a engaged in hostilities against a dissident armed forces or organized armed group meeting certain criteria. But as we've noted here, what about the temporal aspect? Is there any timing-related provisions as to when we can discern the end of an application of additional protocol to conflict? In short, no, there isn't, but there are two provisions, just to be exhaustive here, concerning the end of armed conflict. These relate to deprivation of liberty and denunciation, as well as the end of hostilities in terms of granting amnesty. But these aren't substantive provisions with respect to the scope of application of additional protocol 2. These have more to do with the protective scope following the end of hostilities, following the end of the armed conflict for people in the hands of the enemy, as well as what needs to happen once the conflict ends in terms of attempts to grant amnesty as wide as possible so long as war crimes are not exempted. So, what do you do then? There's so few treaty provisions when it comes to non-international armed conflicts. Of course, treaty is only one main source of IHL, the other is customary law. So sufficient state practice accompanied with what's called opinio juris, or what states consider to be accompanying that state practice because they consider it to be fulfilling a legal obligation or otherwise fulfilling some sort of legal requirement. So the first person we see up here is the judge. This has been the most important area of development of customary IHL, or if development's not the right word, the reflection of the crystallization of customary IHL, in particular by the International Criminal Tribunals, especially the IC2I, or the Criminal Tribunal for the former Yugoslavia. And we'll go into that a little bit more down the road here. Second are academics. So obviously academics cannot be actual sources of public international law. Under the ICJ statute, learned publicists can be supplementary means to discern the scope of application of international law. But in this realm in particular, academics have been incredibly important in beginning to sketch out the normative concerns here. And we'll put forward a few of their theories in a couple of minutes. We noted the NGOs here as well because even though NGOs are not capable of providing acting as a legal source in some way for international law, it's in their interpretation on the ground that often are operationalizing these norms. And so as you're thinking through whether or not you want to invoke IHL or human rights law framing or both, you often, obviously you don't have lawmaking power as such, but it's very important in terms of what states and how states and the warring parties interact on the battlefield, because you have a very, very important role as an NGO. And then the last point here is the Security Council and other UN actors have had an important, stakes. They've had an important role in being able to discern when armed conflicts have ended, even if not as a legal matter under IHL itself, as a political matter, saying that some armed conflicts are ending, or strongly pushing the parties to end the armed conflicts. Getting back to the IC2I for a second. Don't need to look into this in great detail. It's a very small set of type, and I apologize for that. But the key point here is that in the jurisprudence of the International Criminal Tribunals, they've developed two key sets of criteria to look to for the existence of an armed conflict. So when do armed conflicts of a non-international character come into existence? Most of you are familiar with these. These are the intensity and organization factors. Everything on the intensity side, from use of armed forces, the type of attacks, the type of actions, etc., and then very importantly that there's sufficient organization of the parties to the armed conflict. We raise this here because, as we'll see later, there's been much more discussion about the beginning of non-international armed conflict and what the criteria are for the beginning of non-international conflict than about the end of non-international armed conflict. And so these factors can be very important in trying to discern if, in toggling that switch on and off, as Naz mentioned before, do you go through this checklist backwards, some way in reverse, and what are the implications of trying to do that? So here is a map. We tried to go through and say, all right, what actually is happening? What could we say is a non-international armed conflict that raises some of these difficult questions? And so if you go from left to right here, you'll see on the map, on the graph in front of you, red is the threshold of hostilities. So this is what's the level of militant engagement between the warring parties. At some level, where we've designated the CA3 threshold, it goes from internal disturbances to an armed conflict. So this is the minimum level. This seems to be the T2 marker, right? So before then, it seems pretty clear that international human rights law applied and IHL didn't. Between T2 and T3, where you see there's a huge spike in hostilities and then it goes down in hostilities and back to the level that was immediately before, and again, this is looking mostly at intensity and less at organization, but sort of looking at both, you have the application of IHL. We're putting aside here the contentious question of whether IHL, and to what extent, if it does, applies alongside IHRL. The key point here is that at least IHL applies, right? And then what do you do from T3 onwards, right? So you have a dip in hostilities, maybe the organization of the groups is not as good as it was before, and then you have another spike in hostilities, and then it goes down, and then it keeps going down, and then ultimately you have a peace agreement, but that's much later. So how exactly do you characterize, from an international law perspective, the set of violence, the different levels of organization of the parties that you see in the question mark between T3 and T6? From what we can tell from the literature and from the jurisprudence, there seem like three theories that have been put forward today. They each have their pluses and minuses, and I'll try to go through these pretty quickly so we can get to the question and answer. The first one is what we would call the IAC throwback theory. So this is the International Armed Conflict Throwback Theory. And what's happening here is it's based in the ICTY jurisprudence, where it seems as if the court is saying there needs to be a peaceful settlement before we can discern the end of application of IHL for a NIAC. This goes back to the pre-1949 IAC version, where you had the war or peace framing. It's no longer the existence or non-existence of armed conflict on its own. It's also tied in some way now to peace settlement. This has, on the plus side, that it gives international criminal tribunals and other courts jurisdiction over a unfettered period of time. But on the downside, peace may not actually be that apt of a framing for a lot of non-international armed conflicts today. We had this move from IAC to NIAC because we had to move from war to existence of armed conflict precisely because we didn't want to have to wait to be able to toggle off the armed conflict framing, given its permissive powers to kill and detain and do other things, and it unpegs it from the objective criteria that it had before. The two-way threshold theory is one that has been articulated most prominently by Marko Milanovic, and that holds more or less that IHL will cease to apply once the combination of factors that triggered its application in the first place no longer hold. So if you go back to the different criteria that we had with the intensity and organization factors, once those no longer obtain in the factual situation, you'll no longer have IHL of NIAC. This is also subject to some critiques, not least that IHL then would be pegged to an oscillating intensity, as one of the tribunals called it, and the revolving door concerns that accompany it. Also, within the jurisprudence of the tribunals, they sometimes say that you have to have sufficiently protracted hostilities in order for an armed conflict to exist in a non-international armed conflict, and it's not clear exactly how you would measure that protractedness within this framework. And lastly, the Security Council may say something about the armed conflict, about at the beginning of the armed conflict, but rarely these days does the Security Council often come in and say that much about the end of armed conflict. So how exactly would you reverse some of those key factors when it comes to intensity and organization? The last one is what we are dubbing the risk of resumption theory. This one is most prominently being articulated by first by ICRC legal advisor Dr. Tristan Ferraro, and then later and more recently by the ICRC in its challenges report from last fall. What this says more or less is that IHL will continue to apply until some point at which the risk for resumption has receded to the point where there's no longer sufficient risk that hostilities will resume. And it's not exactly clear what legal line this is drawing. It provides that it's the overall assessment of all of the facts within the situation that can be discerned by the relevant actors. This is critiqued because it's somewhat vague and requires on a holistic view of all of the factors, which aren't always available to everybody involved. And it's far less objective, it would seem, in some respects, than some of the other tests that have been put forward. So with that, I will hand it back over to Herod to do some question and answer.
Okay, great. Thanks a lot, Dustin, for that. So actually, we have a couple of participants in today's event who we'd like to bring in on the phone line to add to the discussion here. And what we're going to do, I'm going to first bring in Gai Bartel, who is a legal officer in chambers at the International Criminal Court. Gai has been with us for a number of courses with PHAP, and great to see you here in the event today. So I believe that we have got you on the phone line, and what we'll do is, Dustin, I'll keep you unmuted as well. So I'll go back to you, Dustin. Maybe you can pose a question, get some comment from Gai. The two of you can go back and forth a couple times, and then I'll take back the floor if that works.
Absolutely. Thanks very much. Gai, do we have you on the line?
Yes. Hi. Good afternoon. Oh, well, at least afternoon for me.
Good morning from Cambridge. Thanks so much for joining us. We really appreciate your insight that you have in your own academic work on these issues. And I was hoping we could tee things off here by starting with the accountability piece, right? So this is something that we didn't emphasize a lot, but it's obviously very important. And when a lot of people think today about armed conflict, they think about war crimes and war crimes accountability. So if you could just give us your thoughts on what exactly the discernibility of the end of application of IHL for NIAC means when it comes to individual criminal responsibility.
All right. Well, much of the views on when armed conflicts end, and then specifically non-international armed conflicts, they are either expressed in the international case law or the academic writing derives their arguments from international case law. So these rulings, mainly the ISDY rulings, they impact on what is considered the end of the temporal scope of IHL. But at the same time, the general scope of IHL affects the jurisdiction of international courts and tribunals because war crimes, which, as we all know, are serious violations of IHL. So war crimes can only be committed when IHL is applicable. So in this regard, it's important to observe, and that's often left out, that although we always say that IHL applies during armed conflict, there's actually a number of rules that are either they apply already before an armed conflict in peacetime, or they continue to apply after the relevant armed conflict, be it international or non-international, after it has ended. So breaching the peacetime provisions, they generally wouldn't amount to serious violations of IHL, but you have provisions that relate to, for example, detained persons who are detained in the course of the conflict, and they would continue to protect those persons after the conflict has ended. So if those persons are harmed, killed, tortured after the conflict has ended, you would still have a serious violation of IHL. But if you look at the ISDY statute, for example, it explicitly asks for an armed conflict to be in existence. And also Article 8 of the Rome Statute talks about the existence of an armed conflict, an international armed conflict for A and B, and then for Article C and E, or sub C and E, it has to be a non-international armed conflict. So there seems to be a bit of a discrepancy between the existence of an armed conflict and the application of IHL, which does not always neatly overlap. And in that regard, it's also important to consider that IACs and NIACs can exist alongside each other, and IAC can morph into a NIAC and the other way around. So it's actually more important to look at when IHL remains applicable, because then it can be violated and war crimes can be committed. But having said that, because the jurisdiction of criminal tribunals is affected by this temporal scope of armed conflict, it seems that tribunals, the ICY statute, for example, requires an armed conflict not just for war crimes, but also crimes against humanity. But then the ICTR, Special Court Sierra Leone, they require the existence of a NIAC. And as I said, the Article 8 of the ICC statute requires either the existence of an international armed conflict or non-international armed conflict. So if the prosecution would not show that an armed conflict existed at the relevant time of the time relevant to the charged conduct, then it couldn't be a conviction for war crimes. And the defense normally seems happy to accept that an armed conflict existed if there's a case where crimes against humanity are also charged, because the application of IHL would mean that at least a number of persons could have been killed legally or wounded legally, combatants, persons DPHing, and there could have been proportionate collateral damage or incidental damage, and of course the same count for destruction. But you see that in cases only war crimes are charged, the lack of an armed conflict suddenly becomes very relevant, and because it could lead to an acquittal. And that's specifically these cases that on which the table that you showed with the indicators for intensity and organization, that table is mainly drawn from from the Haridinai case and the Boskovsky case. And specifically in those cases, the defense argued that no armed conflict existed because the accused, they held high positions in Kosovo, Macedonia. They didn't have to fear prosecution back home. So if the ICY wouldn't have jurisdiction over their alleged crimes, then there would be no accountability for that conduct. In Gotovina, similarly, the defense argued that the armed conflict had ended prior to some of the charged conduct having taken place. And it seems, and I mean, I work in ICL, and but I say this in a personal capacity. It seems that because of the dependency on the existence of an armed conflict, the ICY, it arguably has overstretched or expanded the application of IHL well beyond its intended meaning. I mean, especially Common Article 3, which, even though, of course, the commentary of Pictet called for an expansive application, it was meant to be a rather high threshold, really sort of the classic civil war. But it's now lowered significantly, and the same counts for the end of the armed conflict. The peaceful settlement, as you already indicated, that seems to really be in order to not have any discussion over the jurisdiction, over the crimes that are before that court. But in that sense, there's two things that are important. Not only it's important that we live in a different time nowadays, not merely because we have human rights treaties now that weren't there in 1949, but it's now clear that IHL does not just have a protective function. It's not always good to say that IHL applies, at least if you consider it from a protection point of view. The permissive function is stressed a lot, and states were in general unwilling to recognize that a NIAC existed in the past. They're now happy to, especially in transnational or extraterritorial situations, they're very happy to acknowledge that a IHL applies, because that would allow them, at least they argue that it allows them, there's discussions of course as to the authority to kill or detain, but it would allow them to target certain persons. So courts and tribunals, they need to be aware of this, of the consequences that judgments have if they want to stretch the application of IHL, because it would not necessarily provide better protection for individuals on the battlefield. But at the same time, it's also very important that attention is paid to the different rationales between IHL and ICL. IHL, of course, as we know, aims to mitigate the suffering of war, the consequences of warfare, setting certain limits. So it always errs on the protection side. If you don't know if someone is a civilian or is directly participating or a civilian combatant, you have to consider a person a civilian. If you don't know if someone's entitled to POW status, you have to provide that status. But criminal law, it's basically the other way around. There's, and international criminal law is criminal law. So you have the presumption of innocence. So one can wonder then whether international courts and tribunals shouldn't be more restrictive in what they set as the start, and indeed also at the end of the armed conflict, because the rationale of criminal law, the presumption of innocence, might actually require to consider an armed conflict from having ended when the necessary factors aren't met, as opposed to just setting this very forward sort of peaceful settlement end of the armed conflict. And in that sense, I would agree with Marco. I said that myself as well somewhere, that you should go by the intensity in the organization, and that's precisely what is done for the start of an armed conflict by the ICY, the ICC as well. So maybe you should also consider those factors, and you might have to adapt them, but for the end of an armed conflict, not just because it might be the correct way to go, but also because in a criminal trial you will have to err on the safe side in not calling something an armed conflict if it might not be the case. That would be a short view on the matter.
Okay, great. Thanks so much for that, Rogier. It's great that you were able to join us. I know that this is your lunch break, and now you have to go back into the courtroom. So great that the timing worked out, and looking forward to hopefully have you in another online discussion soon. So we're going to be now trying to bring in, I hope we have her successfully on the line. Kate Clark is a PHAP member currently in Afghanistan. She's the country director now for Afghanistan Analyst Network, and has written on this and related topics. Kate, do we have you there? I can hear something. It's very low.
Can you hear me? Can you hear me?
I can only barely hear you. Let's see. I don't know if you can get closer to the phone, perhaps.
I'm about as close as I can get. How's that?
Let's see if we can make that work. I can hear you, but I'm not sure the others can hear very well. Let's see. Yeah, so we're at max volume.
I don't know.
Oh. Okay. Marcus, do we think this will work? Okay. All right. Well, we can transcribe what you're saying, so that should work, I think. Naz, if I could bring you in, I think when we were discussing before the event, you had a question or two that you wanted to try and pose to Kate if we were able to bring her on the line. So over to you, Naz.
Thank you very much, and Herod. Kate, thank you so much for trying to connect with us from afar. I was particularly interested in asking you about some of your work with AAN and your fantastic analysis that, of course, anyone who has worked on or in Afghanistan is well aware of. But in particular, because we're a bit short on time, I wanted to focus on some of your analysis relating to U.S. rules of engagement and the idea that sort of in your work looking at the Kunduz Trauma Center strike, you talk about the idea that there is a whipping up of the rule book or a liberalization or opening up of the targeting rules. And I'm wondering, are you seeing a connection between at least a perceived change?
I think we're okay. Naz, do we still have you?
You do. I'm going to push forward.
Yeah.
Okay. Do you see a connection between a kind of uncertainty about whether or not the U.S. is sort of leaving or staying or is using special forces or is using regular forces and the rules? Are you seeing kind of an effect of this idea that it seems as though the U.S. announced that the war was over and then in some ways continued the war? I'd be particularly interested in your thoughts on how you see it affecting tactics and approaches on the ground. Over to you.
Okay, thanks so much, Kate. The connection was really weak, but I actually think we did manage to catch almost everything, and a really valuable comment. And thanks to Marcus, who was attempting to transcribe, and then Naz commenting on your comments in the chat, really added to the discussion. So thanks so much for coming in on the line. We're running extremely short on time, but on the off chance that that there can possibly be a short answer to this question, I am going to pose one question that did come in, and allow Naz and Dustin to do with it as they will in their remaining time. So we had a question come in from Drew White, who's a PIAP member. He's based in Canada for several years, has been a senior trial attorney with the ICTR, and he writes the following: given the ruling in the Tadich court that IHL applies from the initiation of armed conflicts and extends beyond the cessation of hostilities until a, quote, general conclusion of peace is reached, or in the case of internal conflicts, a, quote, peaceful settlement is achieved, what factors can assist us in making a determination of, quote, peace? Over to you guys.
Thanks very much, Drew. It's a great question, and obviously, as Anherid anticipated, impossible to answer with any respect to its complexity. I'll just say this. Yeah, I think that there is a real question today in 2016 for those who are thinking about this issue in international law terms with what to do with that aspect of Tadic. As much as Tadic's approach to the beginning of armed conflict has sort of achieved some kind of global acceptance as a standard, I think the notion that the peaceful settlement in a non-international armed conflict is the standard, there's a real question about whether that is realistic and plausible in today's armed conflicts. Can we expect that that is how NIACs will end? And if not, do we maintain that as a standard, or as Rogier and Marko Milanovic and others have argued, that we really should stick to Tadic's criteria for determining if there is a NIAC and to run those backwards in order to determine the end? So it's a great question. I don't think there is a good answer, but I share the sense that we look at that notion of peaceful settlement and we wonder, do any of us think that we are going to see those types of settlements in the conflicts raging around the world today? Back to you, Anherid.
All right, fantastic. Thanks a lot, Naz. We're going to wrap things up now. We're at the end of our hour. I'd like to thank PILAC, represented today by Naz Modirzadeh and Dustin Lewis. Thanks so much for being with us for today's Expert IHL briefing. Thanks to all of our participants, both members and non-members, and in particular thanks to Rogier and Kate who managed to connect and join the audio conversation today. It was great to have you as well on the line. A final request or a parting note to all of you, as this is a new series that's well on its way to becoming a long-term series for PHAP. We're actively seeking suggestions for additional topics, other research initiatives that are of particular relevance to the humanitarian community and where there's a need for this kind of higher level briefing for that community as well as the related legal community. If you have any suggestions along those lines, please do get in touch with myself or my colleague Marcus Forsberg, and we'll very eagerly follow those up with you. So then, drawing things to a close today, I'll just point out that the recording of today's event as well as a list of related resources will be available at the link that you see in front of you on the screen. And I will then just sign off from Geneva. This is Anherid Lang signing off from Geneva on behalf of PHAP. A good morning, good afternoon, and good evening to all of you, and looking forward to speaking with you next time. Bye-bye.